And there's a matter that is now before the gun court, and therefore the proceedings are not open to members of the public. Media cannot access because of that. It is an indictment which has charged something under the Gun Court Act, and that is the place where the matter is to be tried. However, some days ago we heard that the defendant, Joylan Silvera, former member of parliament, entered a plea of guilty to manslaughter. We have also been told that the prosecution has accepted the guilty plea, but that the presiding judge is to rule on whether the plea is to be accepted. We're joining legislator, former judge, to just break down for us the provisions under which a judge in a situation like this has the final responsibility to decide whether a plea is to be accepted or not, and also to look at what other matters may arise in a situation like this, irrespective of the decision of the judge, as we await the decision from the court. Thank you so much, Member of Parliament for West Central St. James, Marlene Malahoo-Forte. Welcome, Mrs. Malahoo-Forte.
Thank you, Mrs. Hughes. Good morning to you and to the listeners.
Good to have you. Haven't had you since the start of the year.
Well, Happy New Year to you and your listeners.
And to you, and to you. Yes, I thought I'd call you because this matter is right up your street from so many different vantage points as a legislator, as a former minister, and more importantly, as a presiding judge. What are the issues that come to you with what has been published about this plea that has been entered and accepted, and we're awaiting the judge now deciding whether it is to stand? What is to stand, actually? Yes.
The case is of high interest to the public, primarily because we have a former member of parliament on trial, as many have said. But for me, I look beyond who is before the court to the substance of the matter. And while we await the ruling of the judge on whether the reported negotiated plea to manslaughter will be accepted, there are so many questions that come to mind.
Mm-hmm.
The Plea Negotiation and Agreement Act indicate very clearly that the prosecutor shall in open court inform the plea judge of the existence of the plea agreement before the accused person is required to plead or at any time after arraignment. That is when the person is pleaded. Mm-hmm. And the law also compels the disclosure of the agreement in open court when the plea is offered. But it has a proviso unless the plea judge for good cause allows the parties to disclose the agreement in camera.
Right.
I will pause here.
Yeah, pause. You said the prosecutor to advise.
The parties shall, so the law says that the prosecutor shall in open court inform the plea judge of the existence of the plea agreement. And it can be done at two stages. Before the accused is required to plead, that is before he's arraigned. That's the term that is used in law for the listeners who may not understand. Or at any time after arraignment. So the arraignment is the process by which the charge is formally put to the accused person for him to enter a plea. And the plea has to be unequivocal for it to be accepted.
And the arraignment is normally what? The first, second, third appearance?
Well, it depends.
Yeah.
It depends. Sometimes an arraignment takes place early, but the arraignment is the formal commencement of the trial.
Right. And you say the prosecutor shall in open court advise of the existence.
Inform the plea judge of the existence of the agreement.
And when you say in open court, explain what that means within the context of a matter being tried in the gun court, which is not open to the public. Is that...
So you have court and chambers, and in fact, the provision also says, or on showing of good cause in chambers.
Good.
And in that case, the matter. So the general rule is that matters are tried in public, open court, and there are exceptions to that where the interest of justice demands. And we have numerous provisions.
Mm-hmm.
I note discussion taking place asking the question whether the entire legal framework which accepts open court hearing should be reconsidered. Now, I have some views on it, and I think this case has thrown up some interesting questions. So under the Plea Negotiations and Agreement Act, the existence of a plea has to be indicated in open court, but that's not the end of the matter. Because the law also says that the plea judge shall, before accepting an agreement, be satisfied of a number of things. And of course, the plea has to be voluntarily given. It should not be as a result of force, threat, or promise. The accused must understand the nature, substance, and consequence of the agreement. But the one that is of particular interest to me in this case is that the judge also has to be satisfied that there is a factual basis upon which the agreement has been made. Why is this important? When this matter was first reported, we heard that the accused had completely separated himself from the case. We heard of a cause of death, of the deceased dying in the sleep. We heard so many things about it until investigation, thorough investigation, including scientific investigation with the ballistics, clearly presented a case that was so compelling that it appeared to me, based on the limited information that is reported, that the accused may have had no option but to throw in the towels and plead guilty. But before a plea can be accepted to a lesser count, there has to be a factual basis on it. And the factual basis must meet the requirement. So by way of example, if you are charged with the offense of murder, which is the unlawful with intent to kill, that can be reduced to the lesser count of manslaughter, and you have issues of provocation. If legally made out, you may have diminished responsibility. So for me, I'm curious, what is the accused saying after he initially separated himself from this murder? What is he now saying that would ground this plea? And it leads me to the other issue before you, and the open court.
Okay, before you go to that, then the question is concerning the factual basis upon which the plea agreement has been made. And based on you summing up the reportage of the incident and even other people being possibly said to have caused death and so forth, how much of that reporting must a presiding judge consider, if any, within the context of what he is now considering? Since all of that would almost be perhaps inadmissible hearsay, or some things that an accused could be confronted with as previous inconsistent statement in the context of cross-examination.
So, of course, you know, a case has to be determined on evidence that is before the court. And the facts convert into evidence when rules are applied to them and they can be agreed. And the facts must meet legal requirements. So there is a test of relevance, not just hearsay. And naturally, there are rules which limit what a court can take judicial notice of, but judges exist in a society. So I don't know, and I can't speculate, but the question arises because naturally, what the accused may have presented in early comments or interrogation may be part of the record. What is being used? I think overall, Mrs. Shields, questions arise, and the public, this is a good case to help you educate the public on a number of things. But because I don't know exactly what is before the court, and I think this is part of the reason why there is so much commentary about it. But here is another view that I think those who are clamoring for early disclosure of matters before the court ought to consider. Is the interest of justice served to report on certain things when the matter is not concluded? Let's just say, for example, that the factual basis for a plea of manslaughter is not accepted on the judge's ruling. The prosecutor and the defense are trained lawyers, but the ultimate matter is for the judge. And let us say that enough is not said that would satisfy the court, all things taken into account, what then happens? How does an accused get the kind of fair trial that is required when it is made clear that he has admitted to unlawfully killing the deceased in these circumstances?
Let me take a quick break. Very provocative question. This is the hotline talking with Member of Parliament for West Central St. James, Marlene Malahoo-Forte, former judge, former minister. What a question. Is the interest of justice served to report on something which is not final? And what is likely to be the fate of an accused if a presiding judge decides not to accept his plea of guilty to a lesser offense? What sort of trial can he have when it is known by all parties that he is admitted to an offense less than murder, but manslaughter? The law provides for that, Mrs. Malahoo-Forte. We're back with West Central St. James Member of Parliament, Marlene Malahoo-Forte. Very, very important question. Are you there, Mrs. Malahoo-Forte? This is fascinating. So, whose interest is served, if anyone's, in the reporting of a position that an accused has taken pursuant to a plea deal when the thing has to be subject to a decision by the court where the presiding judge can accept or refuse? Where the plea deal is accepted, then the judge will communicate the acceptance. Let me go to Mrs. Malahoo-Forte. Very, very crucial question, Mrs. Malahoo-Forte.
Yes, Mrs. Shields.
So I was saying that the law contemplates this, where the plea deal is refused by the judge and the director is informed of the decision to refuse and the reasons for the decision.
Yes.
Yes, so I see in section 12.2.
Yes.
So the fact that it is countenanced by the law, how does the question of whose interest is served in reporting this? Tell me how it comes out. Oh, let me go firstly. Here
is what I am wondering about.
Mm-hmm.
Let us say that at the end of the day, especially in a case like this, I still don't know how much is before the court for proper consideration by way of what was reported. But let us say that at the end of the day, the judge says, what you have put before me, there is no basis. The factual basis does not meet the legal requirement for the reduction of the plea from murder to manslaughter.
Yes.
Then the matter would have to go to trial because the charge would not be dismissed.
Well,
or withdrawn.
It could go to trial, or
he could be forced to plead to the
he could replead. Yes,
he could replead.
Yes.
So we look at both case scenario. If he repleads, then that's a less difficult situation.
Right.
But if he doesn't, then the matter would have to go to trial.
Yes.
And the trial would take place before a judge and jury.
Well, no, so, in this case.
Well, it's a gun court matter, so it's a judge alone.
Which complicates it.
So.
Yes. It complicates it, I say that, because in the situation where the judge, as judge, rejects the plea deal, but then he sits in the trial as judge and jury.
It probably would have to be put before a different judge. But a number of questions arise. And this is what I say. Would the interest of justice be better served to have all of these issues ventilated and a determination as to whether the plea is accepted before it is reported on. It's something that we really have to take into account. Public interest is going to be high, but not everything that is in the public interest is in the interest of the public to know at the time that they are demanding knowledge of. We have to look very carefully at what we say. But while I am looking at the legislation, I believe that I see something that may need a little tidying up, because I see a section, I'm looking at section 13 of the law, which compels the judge to refuse to accept a plea agreement. It says, subject to subsection 2 shall apply, where the plea judge decides that A, the offense for which the accused person is charged is not disclosed on the fact, or there is no confirmation by the accused of the agreement or the admission contained in the agreement. And the plea judge shall, in the circumstances, refuse to accept the agreement, inform the parties of the refusal to accept the agreement and the reasons for the decision, and advise the accused person personally that the court is not required to follow the agreement, and give the accused person an opportunity to withdraw the plea. And it goes on to say that the refusal to accept an agreement shall not operate as a bar to the conduct of subsequent negotiations and the conclusion of a subsequent agreement. But while I'm thinking about this, it should not only be where the offense for which the accused is charged is not disclosed, but where the offense for which the accused intends to enter the plea is not disclosed on the fact.
But that is
really,
interesting.
Yes.
Because,
and for practical reason. Right? When you look on the law, and that's why I always say, Mr. Shields, you will hear me say it all the time, the passing of laws is not a simple matter. And you have to think it through. You have to think of how it will operate in law. And, I have the distinction of now being the only person in the parliament who has sat in the 3 branches of government.
Yes.
And you see how the law operates. It's not that I intend to be fussy, but when you pass laws, they must work, and they must work in a practical way.
Yes.
So a judge should not be empowered to accept a plea if the plea cannot be justified on the case. It's not just whether the person is charged with, because this section assumes that the accused will always be pleading to the offense that he's charged with, and not necessarily a lesser offense.
Right. I get that. So, but where an offense such as murder can, with a lawful defense, be reduced to manslaughter, is it your view that an accused in the position of a person entering a plea arrangement should not even be allowed to advance manslaughter on the charge of murder?
Well, I'm sorry, could you just repeat that?
Yeah, so if the person is charged with murder, based on this plea agreement,
yes,
the plea that is to be entered must be in relation to murder only. That's what you're saying? For the offense for which
No. I'm not saying that. I'm not saying that at all. I'm just saying that the way the legislation is drafted,
yes,
that the judge is mandated to refuse a plea in certain circumstances.
Yes.
And the limited circumstances set out in the section 13, is where the offense for which the accused is charged is not disclosed on the fact. And I'm saying that it may need to be expanded to say where the offense for which the accused intends to plead is not disclosed on the fact. So that's my legislative hat being put on. But if we go back to what
it's not disclosed. Yes, hold on a second. So it's not disclosed on the facts.
Because you have to have a legal basis on which you can properly accept a plea to a lesser count. You have to have something that would operate in law in a worst case scenario of a trial to reduce the offense from murder to manslaughter.
Right. So the challenge I'm having is that,
well, we don't know what those what the factual basis
of
would
this,
be,
right?
because
That's
none
right.
of that has been disclosed
But
yet.
forget this case.
Yes.
Generally,
Yes.
even a judge presiding over any trial,
Yes.
he knows nothing about the matter until evidence is laid. There may be some disclosure in proceedings, maybe for bail or something else, or when the matter during case management and so forth. But and whatever he knows will be mostly from the prosecution, or if the defense advances some little thing within the course of maybe now with the plea arrangements that were disclosed to the judge. So I'm just wondering.
So each case though has a file.
Yes.
I'm a little removed from the process, the actual courtroom process. No, but when we had long form prelim, for example, the bundle would be presented to the judge, and you can glean what defense is being mounted from how the cross-examination is conducted, because that is how you see. Now you have a situation where the facts would have to be agreed. So the judge does get something, and you have to know what the allegations are to know that the charge is properly grounded in what is before the court. So yes, but the judge does not always have all of the information all at once.
Yes.
But you do have a fair bit of the evidence before you, or what is intended to be presented as the evidence. But the judge also has to be satisfied that accepting the agreement would not be contrary to the interest of justice. And I'm particularly interested in how the judge will reason out these two factors for the public. Well, so we want to hear the factual basis. And I also, so the factual basis on which the agreement has been made. Right. And whether the acceptance of the agreement would not be contrary to the interest of justice. So I'm saying all of this to say, among the many issues arising, is at what stage do you disclose the existence of a plea agreement? I know what the legal framework is.
I'm up on the headlines. I have to go, but thank you so much for the provocative thoughts and questions and positions. Thank you so much, Marlene. Malahoo-Forte, Headlines Time. Wow. So that was an interesting segue. We expected the decision of the court, and sort of immediately at the tail end of the discussion with Member of Parliament for West Central St. James, Marlene Malahoo-Forte, outlining some of the statutory provisions around a plea deal and asking some crucial and provocative questions about what happens if the plea deal is not accepted. And working it all through, we then had the news item that the Chief Justice has accepted the plea deal of Julian Silvera to manslaughter. And a date has been set for sentencing, we understand. I suspect a request has been made for social inquiry report and all of that as well. And so the next stage in the sentencing will be looking to see whether any discount will be granted as a result of this plea, based on the stage at which it has come. And if there is any discount, how much of the prescribed maximum penalty is a sentence to be discounted by? This is interesting because the fact that a plea has been entered doesn't mean that the sentence will be discounted, because the court will have to bear in mind the time at which the plea came. Is it when, at the first opportune moment, I'm trying to find the exact wording in the statute, or did it come at a time when it was inescapable for a verdict unfavorable on the taking of the evidence to be reached against the accused? I don't know, because the interesting thing about this is the charge was murder. So if the charge was murder, and you knew all along that you did the killing, but something caused you to do it, and something is sufficient to rise to provocation, something said or something done, then why not, from the very first time, put up your hand and say mea culpa? So it'd be fascinating to see how this the sentencing phase goes. And can I tell you, this is the most difficult phase that we'll be entering in. Yeah, the sentencing phase. You'd never believe. 6th of March. This is the hotline.